Thank you very much, Sarah. I'm sorry to have intruded on Hillel's talk. In a sense, I could feel he was picking up momentum, and it was getting more and more gripping as we came through those examples and the magnificent Irish accent. So certainly a hard act to follow. I've been asked to speak about lawfare in the grey zone. In particular, international law, state sovereignty, lawfare, and the delegitimisation of Israel. I'm a professor of international law, so it's mother's milk in a sense. But we get from international law and state sovereignty to lawfare and delegitimisation through the grey zone, sort of like the Twilight Zone film and series. The grey zone is the political machinations that Hillel was describing so well. So what is international law? First of all, it's to be distinguished from private international law. If a cargo load of lumber comes into Rotterdam from Kenya, it's under contract, it's international, but it's a private transaction between the exporter and the importer. International law is also distinguished from municipal law. That contract will be governed under a municipal law of one of those countries or under arbitration rules. International law has its origins in ancient history, treaties in the times of the Greeks and the Romans, the notion that between countries, the law of nations is a natural law. It's in some sense divine. And there's a sense still that international law has a divine authority. Even contemporary international law, which is negotiated in the same way that a sausage is made, you end up with something, but you don't really want to know what's in it and how the negotiations produced it. It's nevertheless seen as produced by a consensus of humanity, and therefore it has some elevated status. But there actually isn't a global king or police force or gendarmerie to enforce it. So there's an enforcement gap in international law. And in distinction to the natural law theory is the positive law theory, which is that law is only law when it's enforceable, and in this case, international law is self-enforced. In the UN Charter, the original conception was that there would be an international peace and security force under joint command of the 5 permanent members, but that never came to be because of the Cold War. So in fact, states simply consent to take on the obligations between themselves. International law is essentially Eurocentric, not just Greeks and the Romans, but we can go back to the Renaissance and Italian city-states, where Milan sent an ambassador to Florence and vice versa, and they conducted their relations, and that system became Europeanized through the Treaty of Westphalia in 1648, where warring states agreed to recognize each other's legitimacy and then exported globally through the colonial era. And so that produced systems of state sovereignty based on consent. It's great that we're discussing this in The Hague today, because the father of international law, often described, is Hugo Grotius, or de Groots, who produced a series of works on public international law that were seminal. And in the field that I work in, law of the sea, Mare Liberum, was his work on freedom of the seas. Interestingly, he was imprisoned because of his involvement in Calvinist disputes in this castle, I think Löwenstein, and he was smuggled out in a chest of books. Just a little Grotius story. So public international law, I've described what it isn't, but it is described as a body of law composed for its greater part of the principles and rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relations with each other. And that's been paraphrased many times. For example, this paraphrasing by Ivan Shearer was the major Australian text on international law for many decades. So first of all, it's a body of law. Secondly, it's between states. States are different from peoples or nations. They're a construct in international law. And the states feel themselves bound to observe that system. It's not enforced upon them by the compulsion or coercion of a gendarmerie. And it relates to their relations with each other. So that involves the notion of sovereignty. Sovereignty is central then to the concept of a state and international law, which gives the state exclusive competence in national internal affairs, whereby it's not subject to international processes, human rights, environment, health standards, without its consent. And all states are equal to other states. This is the fiction of international law. In law we have conceptual constructs, which are legal fictions. A company is one. You can't eat a company. You can't take it home and put it on the shelf. It's a legal construct, an act of the human imagination that has legal form and is extremely useful in the conduct of relations between business organisations. And similarly, the state is a construct for relations between peoples. And the idea of sovereign equality is part of that fictitious construct. I mean, obviously Nauru, an island in the Pacific with 5,000 people, is not equal to India with 1.4 billion people. Both of them have one vote, though, equal in the United Nations. Neither of them is a member of the permanent 5 members. They have sovereign equality. I won't go into the components of a state. I know that Matisse, who will speak after me, will go into that. But there are 4 criteria: population, territory, government, and capacity to enter into relations. So that last one is a bit tricky because nobody recognises Taiwan as having the capacity to enter into relations as a state anymore, since the One China policy resulted in the transfer of the recognition of sovereignty from the Kuomintang in Taiwan to China. Instead, countries wishing to conduct relations with China do it through the Taipei Economic and Cultural Office, because they don't recognise, as a result of Chinese pressure, Taiwan. And so recognition is essential to the 4th criterion, statehood. And it's relevant to discussion today because Palestine is recognised as a state in the United Nations with observer status, but doesn't meet the other 3 criteria about territory, population and government. Can mere recognition of it have a constitutive effect rather than simply being declaratory of recognition of the other factors, land, people and government? So in the 19th century we see in the colonial enterprises around the world extending international law, post-telegraph, shipping, railways. And so Europe expanded its international law system globally and generally sought to avoid conflict through the use of rules which maintained peace. We had the growth then in the 20th century of human rights, environment, space, tax, trade, humanitarian law. But the fundamental of peace and security is something that international law does much more poorly. It's essential to the working of a globalised legal order that we have international law and that it govern relations on day-to-day interactions. But when it comes to peace and security matters, international law is much more challenged. The League of Nations, that was formed after the First World War, broke down. I haven't mentioned the Treaty of Lausanne there. We have another colleague, Lockman, today will be speaking about the Treaty of Sèvres and how it didn't come to fruition. And out of the Second World War, with the collapse of the League of Nations, we have the United Nations born with the objectives of peace and security, friendly relations, cooperation, and harmonising of actions. And its principal 6 organs. Hillel mentioned the Human Rights Council being appointed by the Economic and Social Council of the UN. And so we have committees and councils and commissions under those fundamental organs. One of the organs that I'm now going to focus on is the International Court of Justice as we talk about lawfare. So the Charter for the International Court of Justice is part of, it's appended to the Charter of the UN, and only states can be parties before the court. They don't actually have to be UN members. They can consent to the jurisdiction of the court without being UN members. And hence, for example, Palestine has brought a case against the United States as a consequence of the Trump administration's decision to move the American embassy from Tel Aviv to Jerusalem. The ICJ's composition is independent judges in the same sort of rule of law, respectable language that the Human Rights Council looks to, but doesn't necessarily observe very well. We see the same kinds of language in relation to appointment of judges in the International Court of Justice. And the ICJ, the International Court of Justice, is recognised as the Supreme Court within the UN system. So, for example, when the court gave an advisory opinion in 2019 on whether the UK had decolonised in accordance with international law the islands of Mauritius, in particular the Chagos Archipelago, the decision of the ICJ was later quoted by the International Tribunal for the Law of the Sea, and the tribunal said, we don't need to discuss this issue, it's already been decided by the ICJ. So the ICJ is treated with that kind of respect. It has 15 judges. They're appointed on a regionally distributed basis. So it has a political element where judges are to come from regions, and if you're a disputant before the court and you don't have a judge of your own nationality, then the rules allow you to appoint an ad hoc judge. So there's a recognition there that there's a political element in the decisions of the ICJ. It's not simply a meritocracy, it's based upon regional representation, and there's a recognition of the likelihood of bias needing to be compensated by having at least one judge of your own nationality on the bench. So there is certainly a political element to the International Court's decision. There's also questions that we can raise, and I'm going to try and make up some time, so I won't go into them, about whether the court is a subsidiary organ of the UN, because in fact it's appointed by committees that come under the General Assembly. To what extent does it stand above the politics, the way that one expects a court to do in a federal legal system where you have a constitutional arrangement that puts a Supreme Court in charge of arbitrating disputes between states that form a federation? Or, on the other hand, to what extent is it actually subsidiary to the politics of the system and the General Assembly? The sources of international law are listed in Article 38 of its statute: treaties and conventions, custom, which are practices that have developed over time that countries observe and feel to be compulsory, general principles of law that are commonly adopted, such as principles of contract, judicial decisions in the international system, but also in national systems can be referred to, and the teachings of the most highly qualified jurists, which means the major textbook writers, and authoritative journal articles can be referred to. Well, that's the system of international law. On this quick tour, we now come to the grey zone. And the Centre for Strategic and International Studies in Washington, which one of our colleagues here today, Cynthia Day-Wallace, was a member of, has produced a very interesting set of videos on grey zone conflict, the contested arena between routine statecraft and open warfare. So the grey zone is conflict. It's about conflict between states that takes place without being escalated to the level of outright armed conflict. And it's been described by the UK Secretary of defense as the limbo land between peace and war. So it can take many diverse forms. High-tech represents a recent important element of grey zone conflict, and in its most sophisticated form, it's integrated across these diverse forms. Those diverse forms are military, economic, cyber, and informational. So, for example, military ambiguity involves Russian armed forces not wearing uniforms in Crimea, taking over installations there, but Russia saying, we're not responsible, they're not wearing Russian uniforms, they're volunteers, they're local people. So Russia denies responsibility, it therefore can't be attributed with a breach of international law or an act against peace. Similarly, China is constructing islands in the South Pacific on atolls that are within Philippine waters. They say, oh, these are just installations to assist fishermen shelter in bad weather. But then there are airstrips built upon them, gunnery installations, reinforcement of military positions, but there hasn't actually been an act of war declared here. So we have a military situation that's ambiguous. Another is the arming of fishing vessels, Chinese fishing vessels with reinforced steel prows. So they'll ram other vessels to reinforce China's claim to the high seas in the South China Sea as territorial waters. They even ram US naval vessels. The US then hoses them with high pressure water, but doesn't sink them because they don't want to escalate to armed conflict. Anyway, it's a really interesting area that we could spend a long time on. With the outbreak of COVID in the beginning of 2020, Australia was outspoken about the source in Wuhan and wanted China to deliver information. Over 50% of Australian trade is with China. We found ourselves in an informal embargo. So Australian timber, coal, lobster, and grain was all prohibited from being entry into Chinese ports. It was a form of economic coercion to get Australia to reverse its position. Cyber intrusion. You probably remember that North Korean attack on Sony Pictures for the film The Interview, which was a comedy that played upon an assassination plot against the North Korean president. We have had Iranian attacks on the Israeli water infrastructure cyber system, hosting of criminal organizations that seize control over data systems. For example, my own medical insurance company, all of its clients' details were recently hacked and seized and then released to the darknet by a group based in St. Petersburg. These organizations, criminal organizations, aren't state organizations, ostensibly, but they seem to have state protection and often state officers involved in them. And then disinformation is the spreading of information in the grey zone. In relation to elections, it may be the release of false information through various websites describing slavery of children by a candidate running for Congress in the cellar of a pizza restaurant, or it may be the sowing of political dissent and conflict. I think after the current demonstrations in Israel quieten down, there'll be some examination of to what extent they were inflamed through external intrusion. And psychological operations have been conducted for many years, certainly since the Second World War, with Gregory Rose and others seeking to demoralize Allied troops at that time. So lawfare is actually one of these disinformation operations. It combines law and warfare in the grey zone to delegitimize, criminalize, demoralize, and ultimately demobilize. For example, we have Israeli reservists saying that they won't volunteer to serve under the current government. So lawfare is a form of ideological war, and ideological war against Israel is usually successful. Hillel was listing a litany of successes in lawfare against Israel. Israel has focused its effort on military self-defense. It's become a regional power. Walter Russell Mead recently put out a book where he describes not the US as supporting Israel, but the US is choosing Israel to support it in the Middle East as a stable platform for the extension of US influence. So Israel has focused its efforts on the bottom line, military, in order to ensure survival, and it's neglected the area of lawfare because it's all the fluff, shmum, as Ben Gurion said so long ago. Who cares about the UN? And international law is a part of this ideological attack. It misuses law by applying it in extraordinary ways other than those for which it was designed. And I think that's an element of lawfare that needs to be brought out more commonly. The purpose of a law, and therefore the integrity of the law, is undermined through the practice of lawfare. Again, Hillel's example of the United Nations Human Rights Council is an excellent one because the integrity of the whole human rights endeavour is undermined by the lawfare against Israel conducted there. And all those human rights activists want to brush it aside because it undermines the very foundation of their identity and their mission. So, for example, if Hamas shoots from behind civilians, the idea of international humanitarian law is to protect civilians. But if you put the guns behind the civilians, you undermine the objective of protection, undermining the purpose of humanitarian law. And this lawfare does, in fact, have negative effects. It doesn't undermine the physical survival of Israel, but its negative effects, you can see that's a hyperlink. I had a couple of short videos that we don't have time for. But it undermines psychological solidarity. It can also undermine trade supply as you find yourself subject to boycotts and to objections to engagement, to sister city arrangements, to visiting speakers. And consequently, there's also a decline in international influence, and it reinforces the hostility of those waging lawfare because they are their conviction is confirmed by the successful lawfare action. But it should be remembered all along, this undermines the integrity of the international legal institutions and the rule of law involved. These international law battle spaces are occurring throughout the UN. Here I've listed the UN HRC that Hillel was describing. The International Criminal Court had one complaint that it dismissed concerning the Mavi Marmara flotilla case. There's the situation in Palestine it's investigating. There's the current advisory opinion on illegality of Israeli actions to put on top of the 2004 one. And I won't go through the entire list, but the fora are not just international, they're also national battle spaces. So in a French court to sue the French rail construction company that was building a light rail that was extending into East Jerusalem, it becomes a battle space for lawfare, just the way that the UN does and the way that regional sports organisations do. Just at the moment, Indonesia has denied access to an Israeli youth soccer team to participate in international competition there. And so we see that the lawfare campaign against Israel is a sophisticated and extensive global one. Hundreds of people have been trained, thousands are engaged, it's heavily funded. This is just a few of the organizations, pro-Palestinian organizations, but there are many others involved. Even in 2014, in my own university, which is a regional university, we had 5 Palestinian law deans visit together with an Australian ex-judge. They secured $10 million to fund 20 PhD scholarships for Palestinian lawyers who would all engage in lawfare. So Israel is 3 decades behind in this. It's demoted the importance, and we have NGOs that are taking the lead, many of whom are represented here. And it's a battle that is worth fighting, and it's never too late to fight. Thank you.